A second type of speech that the court has determined not to have constitutional protection is obscenity. Roth versus the United States was a landmark case decided by the United States Supreme Court in 1957, which redefined the constitutional test for determining what constitutes obscene material unprotected by the First Amendment. Samuel Roth, who ran a literary business in New York, was convicted under a federal statute criminalizing the sending of obscene, lewd, lascivious, or filthy materials through the mail for advertising and selling a publication called American Aphrodite, a quarterly for the fancy-free, which contained literary erotica and nude photography. The court interpreted obscenity as material whose, quote, dominant theme as a whole appeals to the prurient interest, unquote, to the average person applying contemporary community standards. In other words, the Roth case affirmed that obscenity was not protected by the First Amendment. Chief Justice Warren Burger came to the Supreme Court in 1969 believing that the court's obscenity jurisprudence was misguided and local governments should be given more leeway to ban obscene materials. In consideration of Miller v. California in May and June of 1972, Burger pushed successfully for a looser definition of obscenity, which would allow local prosecutions. The question that the court had to decide was, is the sale and distribution of obscene materials by mail protected under the First Amendment's free speech guarantee? The court ruled that it was not. It indicated that obscene material is not protected by the First Amendment, thereby reaffirming part of the Roth decision. However, the court acknowledged the inherent dangers of undertaking to regulate any form of expression and said that state statutes designed to regulate obscene materials must be carefully limited. The court, in an attempt to set such limits, devised a set of 3 criteria which must be met in order for a work to be legitimately subject to state regulation. 1. The average person applying contemporary community standards must find that the work, taken as a whole, appeals to the prurient interest. 2. The work depicts or describes in a patently offensive way sexual content or excretory functions specifically defined by the applicable state law. And 3. The work taken as a whole lacks serious literary, artistic, political, or scientific value. The third condition is also known as the S.L.A.P.S test. The work is considered obscene only if all 3 conditions, which together constitute the Miller test, are satisfied. In the years since Miller, many local governments have cracked down on adult theaters and bookstores, as well as nude dancing and public nudity laws. These types of actions have been upheld by the United States Supreme Court.